The first thing Marisol noticed was the folder. It sat on the witness rail in front of the woman, like something she had carried 1,000 times. Before, not clutched, not guarded, just there. The woman herself was the same, upright, hands folded, eyes on the middle distance, while the bailiff read the afternoon docket into the record. Room 11, at the Hargrove County Civil Courthouse, smelled of wood polish and recycled air, and the gallery behind Marisol held maybe 14 people, most of them with nothing better to do on a Thursday than watch a contract dispute work its way toward a verdict. Marisol was 24 years old. It was her first trial as a working paralegal. She had a yellow legal pad in front of her and a pen she had not yet uncapped. Across the aisle at the defense table, a man named Gerald Fitch was already leaning back in his chair. Marisol had watched Fitch work the morning session and had formed a quick opinion of him. He was good, he knew it, and he arranged his body in the room so that other people would know it too. He was perhaps 60, silver-haired, with a suit that fit the way expensive things fit. He had objected 7 times before the lunch recess, won 4, and had spent the break standing near the courtroom door with his associate, speaking in a low voice, while his eyes moved over everyone who passed. He was the kind of man who sized up rooms. When the afternoon witness was called, and the woman with the folder came through the low gate and settled into the chair, Marisol watched Fitch do exactly that. The woman's name was entered into the record by the clerk. She had gray-streaked hair pulled back and wore a dark blazer over a white blouse. She placed the folder on the rail. She did not look at Fitch. Marisol's supervisor, seated beside her, leaned over and said quietly, 22 years. She's testified in 14 federal jurisdictions. She knows more about question documents than anyone in this county has ever seen walk through that door. Marisol looked at Fitch again. Something in the angle of his shoulders said he didn't know this, or didn't believe it, or had decided it didn't matter. The plaintiff's attorney began the direct examination. The witness answered each question the way Marisol imagined a person answered questions when they had said the same true things in enough rooms that the truth had simply become part of how they spoke. She described the methodology. She described the findings. She referred once, briefly, to the folder and did not open it. Fitch got to his feet for cross before the direct was fully finished. I'll be brief, he said. Bert, which Marisol was already learning, meant something different than it sounded. He positioned himself between the jury and the witness in a way that was technically permissible and practically obstructive. You've described yourself as an expert. Can you tell this jury what institution exactly conferred that designation? The witness began to answer. She named the credentialing body, the National Board of Forensic Document Examiners, she said. And Fitch spoke over the last word of her sentence. Right. He turned slightly toward the jury. A private board, not a university, not a government agency. He let the pause sit. You'd agree with me that anyone can start a private board? The witness waited a beat. I would not agree with that, no. I'll move on. He had not moved on. He had redirected. You've been doing this work for how long? 22 years. The sound was barely a word. He looked at his notes. And in that time, would you say you've been, let's be honest here, a specialist, or would generalist be more accurate? I specialize in. I appreciate that. He was already talking. I think what the jury needs to understand is the limits of what we might call decorative expertise, the kind of credential that looks very impressive on paper and functions somewhat differently in. Mr. Fitch. Judge Carver's voice from the bench was not loud. It didn't need to be. It had the quality of a door closing, not a slam, just a firm and final click. You will allow the witness to complete her answers. Fitch turned toward the bench with an expression that was almost a smile. Of course, Your Honor, my apologies. He looked back at his notes. He did not look at the witness. Let me put it plainly. Is it fair to say that your findings in this case are at bottom a matter of opinion? My findings are based on, yes or no, please. Judge Carver set down her pen. Mr. Fitch. The same quality in her voice, but more deliberate now, each word placed. You have now interrupted this witness 4 times in 6 minutes. You have characterized her credentials as decorative. You have demanded yes or no answers to questions that do not admit yes or no answers. A pause. Sit down, please. The courtroom shifted. It was not a loud shift. No one spoke. No chair scraped. But Marisol felt it the way you feel a change in air pressure. 14 people in the gallery were very still. The jury, in their 2 rows, had the careful expressions of people who understand that something important is happening and are trying not to show that they know. Fitch sat. Judge Carver reached to her left and lifted a document from the stack her clerk had placed there. She looked at it for a moment without speaking, and then she began to read. "For the record," she said, "the court will note the full qualifications of this witness, as submitted and accepted by this court on intake." She did not raise her voice. She read steadily, and what she read took a little over 2 minutes. The degrees, the certifications, the national board designation and its requirements, peer examination, supervised casework, ongoing recertification, the 14 federal jurisdictions, the appellate-level testimony, the 2 cases cited in published opinions. She named the year the witness was first certified. She noted the continuing education hours logged in the preceding 5 years alone. When she finished, she set the document down. "The objections raised during cross-examination regarding this witness's qualifications are stricken from the record." She made a note. "The characterization of her credentials as, quote, decorative is likewise stricken. Court is entering a formal notation of this exchange for referral to the State Bar's Attorney Conduct Office." She looked at Fitch. "You welcome to continue your cross-examination, Mr. Fitch, on the court's standard rules of professional conduct. The witness will be permitted to complete her answers." Fitch's associate had gone very still beside him. Fitch himself was looking at the table. He was not leaning back anymore. Marisol looked at the witness. The woman with the folder had not moved. Her hands were still folded. The folder still sat on the rail, closed. She was looking at the middle distance again, with the same expression she had worn when she came through the gate. And it struck Marisol, it struck her fully, in a way she knew she would carry, that this woman had not changed her face once. Not when Fitch talked over her, not when he said decorative, not when the judge began to read. She had simply waited. The way a person waits, when they have done this long enough to know that the truth does not require their help to arrive. Fitch resumed his cross-examination. He was brief this time, in the way the word actually means. 4 questions. He did not interrupt the answers. The witness's testimony was complete by 3:30. At 4:17 that afternoon, as Marisol was organizing the plaintiff's exhibit binders in the small conference room down the hall, supervisor came in and set a printed page on the table without comment. Marisol read it. "A copy of the Bar Association's acknowledgement of receipt. Time-stamped 4:09 p.m. A preliminary review of the referral had been opened. Fitch's active case calendar was under administrative hold pending determination." Marisol put the page down. She thought about the folder that had never been opened. She thought about 22 years. He thought about the 4 times a man had spoken over a woman who knew more than he did, and the way the room had shifted. Not when the judge raised her voice, because the judge never had, but when she simply told the truth about what was in the record. That was all it had taken. The truth read aloud, in the right room, by the right person, at the right time. She uncapped her pen. She wrote 1 line at the top of the legal pad, which was otherwise still blank. She didn't write it for anyone else. She wrote it because she was 24 years old, and it was her first trial, and she had just learned something she intended to keep. The credentials were always in the folder. The folder had always been there.